Hello, this is Matt on the Moon Lambo channel, and I've got some perspective to share with you in this latest Moon Lambo hot jam from attorney John Deaton, who is certainly very pro-XRP. I'm going to go ahead and assume that the vast majority of you listening are already well aware of him. I'll assume he needs no introduction. But wait till you see what he had to say on this idea of overcharging, because he's stating quite clearly that the SEC, the people there, they're just arrogant bullies. He literally said arrogant bullies. And I'd say that's still him playing nice, because frankly, I think it would be reasonable to say much, much, much worse than them. And so he's being, mature, a responsible adult here, right? But yeah, calling them arrogant bullies, yeah, it's certainly accurate. I would say also that a lot of these people at the SEC that are involved with this case, they how could they not be? They have to be dishonest people. They have to be liars, because the stuff that they're putting out here. And look, I've seen a number of these attorneys in the XRP community. Excuse me. And this is not me being critical. It's just an observation that they're being professional, and they're saying yes. These attorneys at the SEC, some of them are very good. I see Jorge Tenreras, an SEC attorney, cited as an attorney that's quote unquote good. But even if he's a good lawyer, he's still being dishonest, because he's clearly either that or he's the worst person at logic on the planet. I mean, the degree of hypocrisy here, it's insane to me. And so even if they're good lawyers, fine, but I don't believe for a moment they're being truthful. I think they're absolutely being dishonest. And so that's why me, even without having a legal background, I like coming on here and saying, like, look at me. I'm a lay person. You listening to this, the vast majority of you listening are not lawyers. What do you think? Just use your own logical mind. Does what the SEC is saying make sense? I sure as hell don't think so. So again, in this video, I'm going to share with you some very interesting thoughts from John Deaton. Before I jump in, though, I do want to be clear. I don't have a legal or financial background of any kind. I'm not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos as a hobby, and that's all that this is, just to be super duper clear. All right, so John Deaton begins. An SEC versus Ripple thread. The most important decision a prosecutor makes is at the very beginning, when he decides who to charge and what to charge. Mickey B. Fresh, who is an XRP community member, showed us the video of Clayton favoring going after the individual executives and not just the company, which is what's here. I'm not going to play the video. It's 1:19 seconds. I prefer to not play videos. I rarely do it on this channel. But anyway, John wrote, I called it a bullying tactic. When I was on the chain, another it's another YouTube channel, crypto YouTube channel, very pro XRP channel, though they talk about other topics as well, so it's not explicitly XRP. But anyway, John writes, when I was on the chain recently, and weeks ago, I said charging Brad Garlinghouse and Chris Larson would prove to be a mistake. If the SEC had sued only Ripple, then it would be a strict liability case. And all the SEC would need to prove is that XRP was a security when Ripple sold it. No need to prove any level of intent or state of mind. But by alleging that Brad and Chris aided and abetted Ripple in selling unregistered securities, the SEC must prove the following, quote, that they knew or recklessly disregarded that Ripple's sales of XRP required registration. Yeah, so it's a much higher bar, to be clear. And then he writes, both me and attorney Jeremy Hogan have stated that because of this higher burden on the SEC, it improves the likelihood that the judge might order the SEC to turn over evidence related to Bitcoin and Ethereum. And so think about that. It increases the likelihood, and that's good for Ripple, the company. It'll be good for, I believe, for Brad and Chris also, but the less likely that this evidence would be turned over if not for the fact that the SEC was being, there being a bunch of arrogant bullies going after Brad and Chris Larson, trying to strong arm them, trying to intimidate them, trying to wreck their lives, and it's gonna bite them. I bet, because I don't know what's in those documents. I'd be willing to place a for-fun bet that whatever's in there, if we get to see that information and it's seen in court, it's not going to be good for the SEC. And I think that's why the SEC is fighting so vehemently against this being admissible in court. They don't want it to be part of the discovery process. All right, and proceeding now. The question of whether Brad or Chris knew or were reckless is a question for the jury, not the judge. Because the government has charged the two executives, the statements made by the CFTC chairman in January of 2020 should be allowed as evidence. And so what's he talking about right there? Well, there was this video here. I'm not going to play this video either, but I'll tell you what happened in it. This is a video again from January 2020. And this is the guy in charge of the CFTC. That's the U.S. Commodity Futures Trading Commission. And he was asked by the host, he's getting interviewed here, she said effectively Bitcoin and Ether, they're already under your purview. The CFTC is governing that. They're not securities. And then she said, what about Ripple? And she meant XRP. She said Ripple, though. She doesn't know any better, I'm sure. So he said, well, it remains to be seen. And he went on in this 38-second clip to cite that, and again, this is over a year ago, January of last year. He cited that they're working with the SEC to determine effectively what is a commodity and what is a security. So at that point in time, they did not know if XRP should be considered a commodity and governed under the CFTC or a security and governed under the SEC. They didn't know. They were still figuring it out. And now, in their lawsuit, what are they claiming? That for 8 years, Brad Garlinghouse and Chris Larson and Ripple did the naughty. They did the no-no. They knew they weren't supposed to do it. They knew that XRP was a security, but they did it anyway. And here you have the guy that's running the freaking CFTC saying, no, I'm working with the SEC. We're not sure what the hell it is. That's... Do you see this? And so do you see why? Then this is why at the outset of this video, I was making this claim. And I'm not just saying it because I'm a pro-XRP guy. I mean, fine, call me biased, whatever. But just use your own logical mind. How the hell was Brad and Chris and Ripple supposed to believe that what they were selling was a security when the SEC and the CFTC didn't know? All right. So anyway, now that back into the thread now. This is back to John Deaton, Attorney John Deaton. Because the government has charged the two executives, then statements made by the CFTC chairman in January of 2020 should be allowed into evidence. Also, the statements of Giancarlo, what's the first name? Is it Chris? Chris Giancarlo should come into evidence. Giancarlo had authored an article stating that XRP is not a security and is, in fact, a commodity. And for the wannabe legal experts out there, it's not hearsay, because it's not being offered for the truth of the matter asserted, that it's not a security, but it's being offered instead to show that Brad and Chris relied on those statements in believing that XRP was not a security. Statements by the U.S. government's own experts in commodities, two former chairmen, might be persuasive to a jury or even a judge. Not only did former chairman Giancarlo, the guy helping the U.S. government with the digital dollar, say XRP was not a security, but less than a year before the SEC filed the case against Ripple, CFTC chairman Heath Tarbert said, and this is what I was just talking about in January 2020, that it is not yet clear whether XRP is a security or a commodity. And here's a quote, "It's unclear, stay tuned, I'd say," end quote. And that's what Tarbert said to Cheddar News Outlet. But 11 months later, the SEC claims that Brad and Chris knew XRP was a security, while the CFTC and the SEC were still trying to figure it out between the two agencies. And why is Bitcoin and Ethereum so relevant? Well, first, Hinman, and by the way, Hinman, for those of you not aware, William Hinman is a former SEC director. He's the one that came out and stated that Ethereum is not a security, and he gave the rationale as to why. And so anyway, first Hinman and Clayton said both were not securities in 2018. Second, in January 2020, Tarbert also said, quote, "We've been very clear on Bitcoin. Bitcoin is a commodity. We haven't said anything about Ether until now. It is my view as chairman of the CFTC that Ether is a commodity." John continues. If the former CFTC chairman stated affirmatively that XRP is a commodity, and the then current CFTC chairman said officially ETH is a commodity, it's certainly reasonable to assume that XRP is not a security. Because Clayton and his crew were arrogant bureaucratic bullies that wanted to send a message or for other personal reasons, choose to sue the two executives, the SEC completely overplayed and overcharged this case. Either there was fraud or there wasn't. And clearly there was no fraud. Yeah, and to be clear, the SEC isn't even claiming fraud on any of the parties that they're going after. Not Ripple, not Brad, not Chris. No fraud. No fraud charges whatsoever. So yeah, I'd say they overplayed their hand. John continues. Hence, the SEC should have just alleged the case in the only way that they can prove a case, and that's over sales in the early years. This case isn't fun for Ripple or these two executives, and it's definitely not fun for the hostages in this case, XRP holders. But I will admit, as a trial lawyer, it would be fun to try this case against the SEC. Oh, indeed, I would not mind seeing John Deaton in action against the SEC. That would be a definitely a killer time. See, so look at us. It's just a bunch of liars. They're just saying stuff that they don't believe to be true, hoping that the legal argument sticks. It's unethical behavior, whatever you think of it. They can legally do whatever they want, fine. I think it's very poor human behavior, and I feel disgusted by it. And this is where we are. It really steams my vegetables. I'll wrap up there. You tell me what you think in the comment section below. You know I love hearing from you, and I miss you when you don't talk to me. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.